please also give access to Niharika as a panelist?
Yes, I will. Sorry, Wendy. I mean, I kept you waiting in the queue.
So we are live in YouTube.
The live?
No,
Okay, great.
no worries.
So, dear students and colleagues, welcome to the third lecture on emergent issues in international commercial arbitration, organized jointly by the Singapore International Arbitration Center and the Center for Alternative Dispute Resolution, Jindal Global Law School. So today our topic is hybrid clauses in arbitration. Hybrid clauses, as you know, that has the character of both mediation and arbitration, or you can do them sequentially. There are a lot of ways in which you can organize them. And our speaker is going to talk about that. And today we have with us Ms. Wendy Lin. Wendy is a partner in the Corporate and Commercial Disputes in International Arbitration, Wong Partnership, Singapore. Among her many accolades, she was selected as one of the 4 most highly regarded litigation practitioners in Asia Pacific under the age of 45 by Who's Who Legal. So she is well known for her skill in arbitration advocacy, as an arbitration practitioner, as a commercial lawyer, but most importantly, as an arbitration strategist. So I would now invite Wendy to deliver her lecture. Ajayji, please give her play her that slide. And Wendy, I think you can share your screen. If you want, you can play it yourself first.
Okay, okay, sir.
Sorry, just give me a second to get the slides up. Sorry, Ajay, I don't have the share screen function. So if it works for you, maybe you can share my slides instead. And then I'll tell you next slide and you just move to the next slide. Otherwise, could you give me the share screen function? Either way.
Ajay, can you please start the shares, give the share screen function to Wendy?
Okay, it's fine. I will tell you next slide and you just help me move to the next slide. Ajay, I'll trouble you with that. Is that understood? Okay, so thank you everyone for the invitation and joining us today. I'm going to talk about hybrid arbitration clauses, as Prof. Gupta mentioned. There are many types of hybrid arbitration clauses, but what I'm going to focus on today, in the interest of time, is what I call an escalation clause. If I can move to the next slide, please, so I can explain. And the next slide. What is an escalation clause? What am I talking about? I'm focusing in particular on multi-tiered dispute resolution clauses. And that means that parties will agree various forms of multi-tiered dispute resolution. It could be mediation followed by arbitration. It could be negotiations followed by mediation and then arbitration. In this lecture, I'm just going to refer to them simply as escalation clauses. Let me give you an example of a type of clause that I'm thinking about. Next slide, please. This is an example of a clause that is found in a club in Singapore called the Tanglin Club. It's a country club. And this is what the clause in the members' rules provides for. First, you would see if there is a dispute between the members, it will be referred to the general manager of the country club for conciliation, essentially negotiation, right? And that procedure is to be completed within 14 days of the initiation of the process, failing which you then move to the next step. And what is the next step? The next step is that the dispute will then be referred to mediation. And again, there's a time frame for the mediation process to take place. If you read the clause, it shall be concluded within 30 days after initiation. What if parties are not able to settle through mediation? It will then move to the next stage, which is arbitration. That's one example of an escalation clause. If I can move on, please. I have another example here, and that is the model clause that you can find provided by the ICC. And ICC, as all of you know, is a well-known arbitration institution alongside the SIAC. And what this provides for is a reference of the dispute first to mediation under the ICC mediation rules. And again, provides for a time frame to undertake the mediation process, 45 days from the filing of a request for mediation, failing which the dispute would then be referred to arbitration in accordance with the ICC rules. Next slide, please. Now, why would parties agree to escalation clauses, you might ask? Why not head straight to litigation? Why not head straight to arbitration? Well, essentially, commercial parties tend to like to put in the preconditions to arbitration, such as negotiation and mediation, because it helps parties, it provides parties with the opportunity to resolve disputes in a less adversarial setting. And if you have a commercial relationship with your counterparty, it could also help you preserve commercial relationships. That's one of the key benefits of negotiation and mediation. And of course, it helps save parties time and money as well. If you can settle the dispute early on, bearing in mind the commercial relationship between the parties, you don't have to go through a lengthy arbitration process. And of course, it's not just the time and the cost, you also take the risk of losing eventually. And that's why commercial parties tend to like to put in those two preconditions to force parties to come together to see if they can settle before taking the last option of going for arbitration. If I can go to the next slide, please. There have been questions that have come up in courts, both in Singapore and in England, amongst others, as to whether escalation clauses constitute arbitration agreements. There is a debate about this, and it's summarized very nicely by the Singapore court in this case, Henry Ling versus Tanglin Club. There are two conceptual concepts. The first concept is that the escalation clause is an agreement to arbitrate, right? The entire clause, you look at the entire clause, eventually parties end up in arbitration. So of course, it's an arbitration agreement. The second view is that no, there is no agreement to arbitrate. Parties only agreed to the first step. So negotiation or mediation. The agreement to arbitrate only comes in later on, conditional upon the first few steps failing. So there's actually no agreement to arbitrate at the outset. The English courts, and I can move to the next slide, please, at Channel Tunnel, took the view that the second view was to be preferred. So the clause in that case provided for disputes to be referred to a panel of 3 experts. And if the expert doesn't reach a decision, a unanimous decision, or either party is unhappy with that decision within 90 days, they can then refer the dispute to arbitration. And the House of Lords took the view that there is substantial force in the submission that the clause is not an agreement to submit to arbitration, present or future differences, but actually an agreement to submit differences to resolution by a panel of experts, the arbitrators providing no more than a contingent form of appeal. In Hong Kong, and that's the next slide, please, the clause is very similar, but instead of referring disputes to experts, it was to be referred to architect first. And then after that, either party can refer the matter to arbitration. The Hong Kong court said, notwithstanding the English House of Lords decision, that he had no difficulty finding that this was an agreement to arbitrate, because eventually, whatever the outcome of the architect's decision, either parties have the right to refer the dispute to what is undoubtedly an arbitration. If I can move to the next slide, please. The Singapore courts agree with the Hong Kong court's view and also found that escalation clauses constitute arbitration agreements, because ultimately what the clause seeks to do is to avoid dispute resolution in court by having the matter ultimately end up in arbitration if either party is not happy with the initial steps. And the court said, why does that analysis not apply to arbitration clauses just because they have the pre-steps of negotiation and mediation? Because at the end of the day, the agreement is for parties to proceed ultimately to arbitration if they cannot reach a resolution of the matter between themselves. So that's the model judicial consensus. Now, some of you might ask, what's the relevance of this very nice theoretical debate? The relevance is this, and I move on to the next slide. If the clause is an arbitration agreement, then they're subject to the provisions and principles of arbitration law. And one of the most important principles is that a party that is subject to an arbitration agreement cannot refer the dispute to court. And if it does start court litigation instead of arbitration, the court is mandated to stay those proceedings in favor of arbitration, especially if the court is in a state that is bound by the model law or the New York Convention. Those two statutes or treaties provide that courts have to stay disputes that are subject to arbitration agreements in favor of arbitration. But if, of course, the court takes the view that these clauses are not arbitration agreement, then there is no agreement to arbitrate and there is no need for the court to stay the court proceedings in favor of arbitration, which, if you think about it, is a slightly odd principle, because parties actually did agree via the clause that they wanted their disputes resolved in a manner other than court litigation. So that is why the Hong Kong and the Singapore court approach is probably more correct than the Channel Tunnel English approach. But of course, if you start court litigation and you haven't taken the pre-steps before arbitration yet, the court is not going to immediately refer you to arbitration. What the court will do is to say, well, parties, go on and proceed with the process that you've agreed to. And so if that includes mediation and negotiation, then undertake that first before proceeding to arbitration. Can I move on to the next slide, please? Now, because the escalation clause is an agreement between the parties, like any other contractual terms, parties can always agree to renegotiate them or to depart from them. And one needs to be careful about agreeing to depart from preconditions if that is not your intention, right? In this case that I'm giving you an example of, IS Prime, the court found that there was an agreement between the parties that they could do away with one of the preconditions, which was actually, in that case, quite interestingly, non-binding arbitration before litigation. So the court found that parties agreed to do away with the non-binding arbitration. How did the court reach this view? If I can move to the next slide, please. The counsel for the defendants sent a letter to the claimant saying, well, since the non-binding arbitration is just non-binding, it's more advantageous if we actually go straight to court processes. The claimant responded to that letter by commencing an action in the UK courts. The defendants then regretted somewhat what they said, and they applied to court to say, well, you need to stay the court litigation because parties agreed to non-binding arbitration. Well, unsurprisingly, the court said no, because there's actually an agreement between the parties to depart from the non-binding arbitration. The defendants made an offer to do so in the letter, which was accepted by the claimant when they commenced arbitration in court. Besides departing by agreement, next slide, please. Parties can also be found to have waived conditions precedent. So again, one needs to be careful when you are out in practice and you're acting for clients, not to conduct yourself, not for your clients not to conduct themselves in a manner that is consistent only with not having to insist on the preconditions, if actually what they want to do is to insist on the preconditions. Now, what's the standard for considering whether someone has waived a condition precedent? The court will first need to find that the party has knowledge of the relevant escalation clause. And second, that it has communicated clearly and unequivocally that it would not insist on the condition precedent to arbitration. So you have to behave in a manner that is consistent only with you saying there's no need for negotiation or mediation, let's go straight to arbitration. Now, I'll give you an example of what can satisfy this relatively high threshold. And if I go on to the next slide, please. And that's in a recent English High Court case of the Republic of Sierra Leone versus SL Mining. What happened is the defendant commenced arbitration against the state. The state brought a challenge to the tribunal's award. And the state Sierra Leone said, well, the clause requires parties to negotiate before arbitration. And more importantly, we were supposed to wait 3 months before, after the commencement of negotiations before we can arbitrate. But SL Mining started the arbitration just 6 weeks after negotiation. And so they breached the precondition, and therefore the tribunal has no jurisdiction to hear the matter. That was the argument that was made by the state. If I can go to the next slide, please. The court rejected this argument on a number of grounds. One of the grounds is this, that actually Sierra Leone had waived the condition precedent to arbitration because of its conduct in the arbitration itself. So what happened after SL Mining started the arbitration is that they filed an application for emergency relief. They appeared before the emergency arbitrator. The SL Mining suggested that they serve the request for arbitration only after the end of the 3-month period because it had in mind the escalation clause. Well, Sierra Leone said, no, don't wait. Why are you waiting? Since you've started the arbitration, serve me the request for arbitration now. Now, again, unsurprisingly, because they made such a clear statement to this effect, the court said, well, you can't then rely on the fact that they served you the request for arbitration 6 weeks before negotiation to say that they failed to comply with the condition precedent. You asked for it, and that was what was done. So in a sense, you have waived your right to insist on the condition precedent being met before proceeding to arbitration. If I can go on to the next slide, please. Now, this is something that has troubled many practitioners and would be of some relevance to all of you if you come out in future and practice and you're drafting escalation clauses. The courts have held that the clauses need to be sufficiently certain in order to be enforceable, right? You don't want to draft a clause for your client and put it in a contract, and then later on the court finds it's so uncertain, nobody knows what's the process is supposed to undertake, that is unenforceable, that it fails to uphold the party's intention. And why is this relevant? It's relevant because in England, if I can move to the next slide, please. In this case called Walford versus Miles, the House of Lords said, well, it's a long-standing English principle that an agreement to negotiate is unenforceable. And you will remember in many of these clauses, the first step is always an agreement to negotiate. So if that's found to be unenforceable, then the escalation clause will not be given any effect. If I can move to the next slide, please. And the reasoning for the House of Lords as to why an agreement to negotiate is unenforceable is this. When parties are negotiating, they tend to have different positions, adversarial positions. And how does one negotiate in good faith? Because one needs to push your own position, right? And what if you threaten to withdraw from the negotiation just so that the other side would give you what you want? Is that considered to be breaching your duty to negotiate in good faith? And so the House of Lords said, well, it's unworkable in practice. A bare agreement to negotiate is something that we just simply cannot enforce because we don't know when someone has breached and when someone has not breached the clause. It simply has no legal content. If I can move to the next slide, please. That principle was held to apply to escalation clauses by this High Court case of Tang versus Grant Thornton. The court held that the principle applies to escalation clauses. And a provision for dispute resolution, which lacks sufficient detail as the process required, cannot be enforced. Okay, the court in that case said, well, like, look, I know the provision is part of a contract that's legally enforceable, so we would try as our best to find a construction of the clause that will give it legal effect. What is the clause that is found in the contract in that case? The next slide, please. It's very similar to what we've already seen people using in their contracts. First, if there's a dispute, it's going to be referred first to the chief executive in an attempt to resolve the dispute by amicable conciliation. Very similar to one of those clauses that I showed you earlier. Then the chief executive is going to try to resolve this dispute within 1 month. That's step B. And if the chief executive can't do it, then step C, it'll be referred to a panel of 3 members to be selected by the board for mediation. And then again, the panel is going to try to attempt to resolve the dispute within a month. And step D, if that mediation fails, then parties can refer to arbitration. Now, how many of you think that this clause is enforceable? If I can move to the next slide. The court said that it was not enforceable, notwithstanding that it tried to give it a construction, notwithstanding that it said it should try its best to uphold construction clauses. And what the court said is this: I have reached a clear conclusion that the clause is too equivocal in terms of the process required and too nebulous in terms of the content of the parties' respective obligations to be given legal effect. And in particular, the court said that the omission to give any guidance as to the quality or the nature of the attempts to be made to resolve a dispute or difference renders the court unable to determine or direct compliance with the provisions of ABC. ABC, if you may recall, set out the steps of conciliation and mediation. And what the court is saying, I don't know if it has been breached or if it has not been breached. How many times, for example, is the chief executive supposed to try to conciliate? How many times is the panel supposed to sit down with the parties to try to mediate the dispute? What is the panel supposed to do? How long are the discussions they're supposed to have? You know, if you only sit down and discuss for 20 minutes, is that considered to be sufficient? Or would you be considered to have breached? And the court said, I don't know. So it's too unworkable. This is not an enforceable clause. Now, you might think that's quite odd because, you know, if it's a pretty detailed clause and parties obviously address their minds to it. And these are commercial parties, including Grant Thornton. And notwithstanding that, the court said it's something that was unenforceable. This pattern continued in the next case that I'm coming to. The next slide, please. It's the Court of Appeal decision of Sula America. And the clause in that case, you can see it's extremely lengthy. I'm not going to read it. I put it up there. Somebody took the effort to draft this very extensive clause. One part of it provides that parties will undertake, prior to a reference to arbitration, to seek to have the dispute resolved amicably by mediation. The Court of Appeal said, in the next slide, please, it's unenforceable, notwithstanding this very dense wording of the clause. The court said, well, I don't know how the mediation process is supposed to take place. Who will appoint a mediator? It just simply says refer parties to mediation. How's that supposed to work? And that was notwithstanding the court saying, no doubt parties intended the condition to be enforceable. And obviously, because someone took the effort to draft a very extensive clause. If I can move to the next slide, please. I'm giving you another example that's in a decision called the Emirates Trading Agency versus Prime Mineral Export. The clause in that case is parties shall first seek to resolve the dispute by friendly discussion. And if no solution can be arrived at between the parties for a continuous period of 4 weeks, then the non-defaulting party can invoke the arbitration clause. Non-defaulting party meaning the party that's not alleged to be in dispute. Now, again, I'm going to ask you that question. Do you think this clause was upheld by the court, or the court found it to be too uncertain and so unenforceable? If I can move to the next slide. For those of you who thought that it was unenforceable, there is some basis for your thinking, because at first sight, the clause seems to have suffered from two defects that we have gone through already. First, it required parties to engage in friendly discussions, and we've seen the English courts have said an agreement to negotiate in good faith is unworkable, but that seems to be what the clause provides. And second, there is no specific process for the negotiation. How many times are parties supposed to negotiate? But the High Court said it's enforceable. There is some legal content. You have to try to discuss and resolve the dispute for 4 weeks. And if not, then you can go to arbitration. That's sufficient certainty. How did the court reach this conclusion, which seems to be at odds with the prior decisions? If I can move to the next slide, please. First, the court distinguished Walford versus Miles, which was the English court case, House of Lords case, saying that an agreement to negotiate in good faith is unenforceable. The court said that's just a standalone agreement to negotiate in good faith, and there was no contractual relationship between the parties. It's different here. The escalation clause is found in a contract. There are particular disputes that parties will address their minds to, and that's what they're directed to try to negotiate and settle. So it's not something. If I can move to the next slide, please. It's not something that parties are just discussing, a bare agreement to negotiate, discussing without context. There is context. There is a dispute. We talk about the dispute and we see whether there's any way that we can resolve it. The court also said, well, look, and this is the point that I made earlier, commercial parties enter into contractual obligations expecting it to be upheld by the court. And if not, it really frustrates that expectation, which is not what courts should be doing. And further, it would be in the public interest to enforce an agreement to negotiate, because I've talked about how commercial men expect the court to enforce the obligations. And second, the whole point of the clause, as we talked about it, was that people want to try to negotiate to see if they can resolve a dispute so that they can otherwise avoid an expensive and time-consuming arbitration. Then what about the lack of certainty? Next clause, please. The procedure, how many times people need to negotiate, etc. That was the decision in Sula America, if you may recall. The reference to mediation was found to be unworkable. The court said that's different. Sula America concerned an agreement to mediate, not an agreement to negotiate. An agreement to mediate is different from an agreement to negotiate because, as some of you may know, mediation means that parties refer the matter to a third party, a neutral third party, who will try to resolve the dispute for the parties. The court said negotiations between the parties directly is different. There's no need for a third party to be appointed. There's no need for the parties to go before the third party. The two contractual parties are just going to sit down and try to see if they can settle the dispute. And the last point on the slide is what I said earlier. The court said it's not just going to be an open-ended discussion. People are actually going to talk about the actual dispute at hand in the context of their contractual right and obligations. So that has sufficient legal content. And if I can go to the next slide, please. The court said the obligation to resolve a dispute by friendly discussions has an identifiable standard. Basically, a party should engage in fair, honest, and genuine discussions aimed at resolving the dispute. The court did accept that it might be difficult to prove someone has breached this obligation, but it doesn't mean you go to the extreme and say that it shouldn't be upheld at all because it lacks content, because there is some content, and there are circumstances where a party's breach could be clearly identified. For example, if someone just simply refuses to participate in the negotiation or friendly discussions at all. And so ultimately, the court held that it's a mandatory that the clause is enforceable. It has a mandatory obligation that parties need to resolve their disputes via friendly discussions and would have to wait 4 weeks before they can invoke arbitration. Next slide, please. I'm going to the next case. This is the case that I touched on earlier for a different point on waiver. This is the Sierra Leone case. The clause there provides for parties shall in good faith endeavor to reach an amicable settlement. And in the event they are unable to reach an amicable settlement within a period of 3 months, they can then refer the matter to arbitration in the ICC. And there are two questions that are before this court. First, is there a binding obligation to negotiate? And second, do you need to wait 3 months before arbitration can be invoked? If I can go to the next slide, please. The first question was answered, yes, parties are obliged to negotiate in good faith, applying the position that was taken in Emirates. However, the court said there's no need for parties to wait 3 months before invoking arbitration. And the court said, if I read the clause, unlike the clause in Emirates, there's no, the obligation to wait 3 months is not presented as an independent obligation. It's subsidiary to the overall obligation to seek an amicable settlement. And so if parties are unable to achieve a settlement, as long as the objective can't be achieved, then you can start arbitration. There's no point waiting for 3 months. If I can go to the next slide, please. I'm comparing for you the clauses side by side. And at first blush, when I just read the two clauses, they seem to be indistinguishable, very, very similar. But I think at the end of the day, if you read carefully the Emirates clause, it does say that, the important words are continuous period of 4 weeks, then the non-defaulting party can invoke arbitration. On the other hand, for Sierra Leone, it simply says, in the event parties shall be unable to reach an amicable settlement within the period of 3 months. It's not in that definitive language of Sierra Leone. And it's, the use of the word within the period of 3 months suggests that at any time if you are unable to reach an amicable settlement, you can move to arbitration. So, this emphasizes the need for really precise drafting so that you know what you're binding your client to when you're drafting multi-tiered dispute resolution clauses. The position in Singapore is similar. If I can move to the next slide. The courts also provide for the test of sufficient certainty. And you see, I'm giving you these examples of multi-tiered dispute resolution clauses, so you can see the great variety that's out there. So in this case, parties agreed that they were going to try to resolve their disputes via various steps. So the first step is it will be referred to the parties' contact persons in the contract for review and opinion. They can't reach an agreement, then it will be moved up to a higher level of seniority. So for Lufthansa, it will be the Director of Customer Relations. And if they still can't resolve it, they will move up to another higher level. And in this case, for Lufthansa, it will be the Managing Director. And it's only if parties are still not able to resolve their disputes, then you can refer it to arbitration. So really, parties can decide and tailor for themselves the steps that they wish to be undertaken before a reference to arbitration. Any guesses as to whether it was held to be enforceable? If I can go to the next slide. The High Court said, yes, it's enforceable. Sorry, if I can go, yes, it's enforceable. It's a very clear process. First, it tells you the various steps. It refers parties up the chain if disputes can't be resolved. And you can easily tell if there is a breach or if there's not a breach. And there's nothing uncertain about it. On appeal, the Court of Appeal agreed that the clause was enforceable. And it said that the language was clear. It set out in mandatory fashion and with specificity the personnel from the respondent side who was required to meet with the DataMed's destinies as a part of a series of steps before arbitration. It further specified the purpose of each meeting. The purpose was to review the dispute and to see if the matter can be resolved. If I can go to the next slide, please. And this was the first clause that I showed you from the Tanglin Club case. You may recall conciliation, mediation, arbitration. When I looked at this, I wondered whether the mediation clause suffers from the same defect as the Sula America case because it provides for reference to mediation. How is the mediator to be appointed? Is there an issue as to whether this clause is enforceable or not? In that case, however, the dispute, sorry, if I can go to the next slide. The court did not have to directly deal with the issue, but if the court had to deal with the issue, it would have likely found the clause to be enforceable because the mediation clause, it's not just refer to mediation and nothing more. The rules in the appendix actually provides for a process by which the mediator will be appointed. It's a bit small, I apologize for that, but at the center you would see the mediator was to be appointed by the board within 7 days. And the mediation was to be conducted within 30 days unless parties agree to extend time. So there was a process by which a mediator could be appointed to try to mediate the dispute. If I can go to the next slide, please. Just other examples, I'm not going to go through them. The first one, just a clause that parties will settle a dispute amicably by negotiation was held to be enforceable. And if parties intend to bind themselves to negotiation or mediation as a condition precedent, then they have to say that clearly. In this Singapore High Court case, Cheong Teck Cheong, Richard, what was stated in the clause is that parties shall consider resolving the dispute through mediation at the SMC, and the court said consider mediation just means consider mediation. You don't actually have to mediate. You can, as long as you've considered it and you don't wish to take it, then you can head straight to arbitration or court proceedings. If I can move to the next slide, please. So let me sum up all these various cases that I've gone through. What are the points to bear in mind if you are drafting a clause or if you're looking at a clause to decide whether it's enforceable or not? If it's an agreement to negotiate based on the recent trend of cases, as long as it would likely be upheld, as long as you provide some certainty for it, in particular, the period within which the negotiation should take place. So parties shall attempt to negotiate the dispute, and if the dispute is not resolved within 7 days, so there is some certainty to it. The next step, if the next step is going to be mediation, based on the cases, you would have to specify mediation, the mediation process, what rules, and I think most importantly, how to appoint the mediator. If it's simply parties shall refer the matter to mediation, full stop, then following from Sula America, that might be hard to implement because if parties can't agree on a mediator, then how? If you actually set out the agreed process, then even if parties can't agree, usually there'll be a body who appoint. It's the ICC, or it could be Singapore Mediation Center, Singapore International Mediation Center. And it's also important to provide a period within which the mediation process has to take place, failing which then parties can proceed to arbitration. It's also important to use sufficiently certain and unequivocal language that parties will commit to this process. I gave you the example just now, shall refer and not shall consider mediation. The latter is not sufficiently certain to say that someone has to go through that process before arbitration. The next point that I want to touch on, if I can move to the next slide, please. Is what happens if a party doesn't comply with the conditions precedent to arbitration? And how do you know how much compliance is required? If I can move to the next slide, please. You've seen some of the clauses. They're extremely complex in terms of, or complicated in terms of the steps that need to be taken prior to arbitration. Does party really need to go through all of those steps before you can go to arbitration? Or is it sufficient for one to say, well, in substance, more or less we have complied, right? So we can go straight to arbitration. We don't need to go through or to go through the entire process and wait so long before we go to arbitration. That issue came up in the international research case. Next slide, please. You may recall that's the case where there were various levels of people who will try to settle the dispute. In that case, what happened was parties didn't go through these various levels. There were various meetings between various representatives from both sides, and it was argued there was substantial compliance. There's no point going through the whole process again when actually representatives from both sides have already met and talked about the matter and they couldn't settle it. So why do we have to go through, the steps that are set out in the clause? It's simply a waste of time. Next slide. The High Court agreed. The High Court said, yes, the object has been met because, as I said, right, high-level meetings between representatives of both sides, several rounds. If it can't resolve the dispute, they're not going to be able to resolve the dispute even if you go through those detailed steps. That finding was overturned on appeal, and the Court of Appeal said that it cannot be that parties intended some meetings between some people in their respective organizations discussing some variety of matters would be sufficient to constitute compliance when the clause provides for a very specific procedure as a condition precedent. And so the court said, unless there is a question of waiver, then it must be complied with before parties can proceed to arbitration. So what we learn from this is that if the clause that you have at hand sets out with a lot of specificity the steps to be taken prior to arbitration, then there should be compliance with each step before you can proceed to arbitration. Now, what happens if a party doesn't comply with arbitration and doesn't comply with the condition precedents and arbitration has been commenced? Does that mean that the tribunal lacks jurisdiction to hear the case, or is it just a question of admissibility? Next slide, please. Next slide, please. Yes. And if I can go to the next slide, please. What's the difference between jurisdiction, whether it's an issue of jurisdiction or whether it's an issue of admissibility? If it's an issue of jurisdiction, what you're actually saying is that the tribunal, the arbitral tribunal that has been constituted, has no authority to hear the case at all. And the importance of that is that, so what you're trying to say is that this tribunal cannot hear the case. Some other forum is supposed to hear the case. That's the position when you take an issue of jurisdiction. And the importance of a jurisdiction argument is if you are able to show that the tribunal lacks jurisdiction, that is a ground for setting aside awards in many countries. It's a ground that's set out in the model law. It's a ground that's set out in the New York Convention. So basically, if it's a jurisdiction issue, no arbitral tribunal can hear the case, has the power or the authority to hear the case, or to hear anything relating to the case until after all the various condition precedents have been met. If it's simply an issue of admissibility, and that's the next slide, what it means, it's not that the tribunal has no authority, it's simply that the claim, it's not ripe to be heard at this point in time. The tribunal still has jurisdiction to decide on matters. And crucially, and that's my second point, the tribunal assumes jurisdiction, then the tribunal decides whether a claim is admissible or not. And the importance of categorizing it as an admissibility point rather than a jurisdiction point is that an arbitral tribunal's decision on admissibility, it's a decision on the merits. And in most model law countries, that will be held to be a decision that cannot be reviewed by the courts. As some of you may know, the tribunal's award can only be set aside by the courts on very, very limited grounds. Most courts, model law courts, will not set aside the arbitral award simply because the tribunal got it wrong. They say, well, if parties agree to arbitration, then you're bound by the decision, whether it's right or wrong in your view. The court is not going to step in to interfere. The court can only step in to interfere in very limited circumstances. For example, as I mentioned, if it finds the tribunal had no jurisdiction to hear the case in the first place, or if there's something that went on in the process, for example, breach of rules of natural justice, those are usually very hard to make out, or that the award is contrary to the public policy of a country. But if it's simply an argument that the tribunal, there were two competing views and the tribunal preferred the view of one over the other, it will be said that this is a decision on the merits and you can't seek to challenge it to try to set it aside in court. And that's the last point that I make. If it's found to be an admissibility point, the tribunal's decision as to whether the preconditions have been complied with, as to whether the claim can be heard or not by the tribunal, it's final and it cannot be challenged. And next slide, please. For many years, the courts have treated this point as an issue of jurisdiction. And so there were a number of disputes that came up before the courts as to whether condition precedents have been met. And there were also cases saying that they're not met. And therefore, the arbitral tribunal had jurisdiction. And so the whole award is void. And that was the decision of the Court of Appeal in International Research. You might recall the court said that substantial compliance is not enough. You need to comply with each of those steps. And because it hadn't been complied with, the tribunal did not have jurisdiction over the dispute. And the court set aside the tribunal's decision on the dispute between the parties. And similarly in Emirates, the court said that the arbitrators have jurisdiction to decide the dispute because the condition precedent to arbitration was satisfied. Next slide, please. This issue has recently generated interest again, because starting from this decision of Sierra Leone, which I've gone through, the courts have now seemed to move to a different direction and to treat this issue as going to admissibility instead. And I'm reminding you of the clause in that case, shall in good faith endeavor to reach an amicable settlement. And if not, then parties can refer the matter to arbitration. And you may recall there was a dispute as to whether that condition had been complied with. In particular, SL Mining had served the request for arbitration after 6 weeks of negotiation instead of 3 months. So the argument was rejected on a number of levels, but one of the points that the court had to consider, sorry, if I can go to the next slide, please. I'm reminding you of the facts of the case. There was a written notice of dispute was served. Second point, parties discussed for 6 weeks, and then SL Mining served the request for arbitration. And Sierra Leone said, well, because that precondition to arbitration had not been met, the tribunal lacks jurisdiction. It then applied to court to set aside the tribunal's award on that basis. And the court considered, well, is this even a jurisdiction issue? If it's not a jurisdiction issue, then we can't set aside the tribunal's decision that the claim, that the precondition to arbitration had already been satisfied. And next slide, please. The court said, next slide. Next slide, please. Sorry, if I can go to the previous slide, my apologies. Sorry, next slide. I think we are skipping slides. Okay. It's okay. Anyway, so basically the court found that it's an admissibility issue. It's not a jurisdiction issue. And the court basically said, look, parties are not saying that this claim can't be heard in arbitration. That's a jurisdiction issue. A jurisdiction issue is if we are saying you can't go to arbitration, you have to go before the court. That's not the kind of dispute here if you think about it. The claim is still a claim that should be subject to arbitration. You're simply saying it's brought too early because you haven't complied with the precondition to arbitration yet. An analogy is drawn with limitation issues. Limitation issue is if you say that a party has brought a claim after the limitation period has run out. Those are considered to be admissibility issues as well. So why is an argument that the precondition to arbitrate hasn't been satisfied? Why is it not an admissibility issue? And so the court said actually, the last point, you're only saying that the claim has been brought too early. You're not saying that it's not arbitrable or that some other forum should be hearing the case. So it's an admissibility point. It's not a jurisdiction point. And what does that all mean? Last slide, please. It does mean, I think we have a slide that skipped. It's jumping from 51 to, if I can, yes, so basically, if I can just complete the picture, Singapore courts haven't made a definitive decision on this issue because it previously took the position that is a jurisdiction issue, but it hasn't had the chance to revisit this point yet. In civil law countries, most of the countries have taken the view that it's an admissibility issue, not a jurisdiction issue. Next slide, please. And what does this all mean? It means that parties can no longer try to go to court and allege that condition precedents haven't been met in the hopes of setting aside the tribunal's award on jurisdiction. And instead, whether a party has complied with the preconditions or not, it's a matter for the tribunal. And importantly, the tribunal can also say, because the tribunal has jurisdiction to hear the matter, I'm just going to suspend proceedings for 6 weeks while you go and complete the process that you've agreed to negotiate and mediate before you come back to me. So it supports compliance by the parties with the preconditions, because ultimately the tribunal can direct that parties go through the process if the tribunal takes the view that the process hasn't been complied with. But there will always be those who, it's still being debated, this issue quite heavily by some academics. And the point is this, well, if someone says, I only agreed to arbitrate if we actually went through negotiation and mediation, and if my counterparty actually hasn't done that, then I actually didn't consent to arbitration. Why isn't this something that isn't a matter that goes to the jurisdiction of the arbitral tribunal? And why isn't this a matter that should be heard by the court? Because I didn't agree to submit any dispute to arbitration unless we've gone through the preconditions to mediate, preconditions to arbitration. And so my position is that the arbitral tribunal has no jurisdiction to hear the matter. So this view is still a view that parties are pushing. And I don't know whether in the future we might see a further shift back to finding that this is an issue of jurisdiction. But because it's a pretty interesting issue, you see it being talked about in arbitration webinars. It's also been the subject of a number of essay writing competitions targeted at university students or younger practitioners. It's also been the subject of a lot of academic commentary. And I'm not sure that this is the final word. Keep a lookout. You might see a shift back in the other direction in the near future. And I'm just going to pause. I've come to the end of the presentation to see if there are questions for the parties.
Thank you, Wendy. So I think we have a number of questions. Some of them are from the students and some of them from the practitioners. So yes, the student questions are in a very somewhat different tone. So the first question is from Harshit. So Harshit is asking me that why would the court in the Channel Tunnel Group case consider this to be as a kind of future disputes to arbitration? And is it necessary that you always refer to something institutional to get it enforced? I think he's talking in terms of clause D of ICC.
Yeah, if you're talking about the Channel Tunnel case, the debate there was whether a multi-tiered dispute resolution clause can be considered an agreement to arbitrate, or is it not an agreement to arbitrate? It's only an agreement to proceed with the first step, negotiation or mediation, and the agreement to arbitrate only comes in later. And so the House of Lords took the view that it's not an agreement to arbitrate, it's an agreement to go first with the first two steps, and it only submit up to arbitration after those first two steps have been completed. That's why it says it's not an agreement to submit to arbitration, present or future differences. It's only an agreement to go through the first two steps. I think that's the Channel Tunnel decision.
Yes, and there's also two more questions. I'll just take them together.
Okay.
So the question is that, is it necessary that you need to have a time limit and you need to refer to institutional or some prescribed rules for the
Yes.
certitude to arise?
I think that is, I would say, the best drafting. It will be the model clause. You would see it in all the model clauses. You refer, if you refer to an institution, it's the best because there will be prescribed rules. So, mediation by an institution, as I explained earlier, if you can't agree on a mediator, there'll be rules in that in the institution's rules to which will set out how to appoint a mediator. So that resolves any issue of uncertainty. The reason why I suggested that you should also put in a time period is it adds certainty to the clause. Because if we don't put that in, then when can someone ever refer the matter to arbitration? Which is the parties agree to mediate. If the dispute can't be resolved by mediation, parties shall then refer to arbitration. So what if someone says we mediate for 2 days and we can't resolve it? I want to start the arbitration. Someone else might say, no, you know what? We're not done mediating. We will just keep continuing mediating, and it can give rise to delay tactics by a defendant or respondent who doesn't want to go to arbitration. You will just keep saying, we're not done discussing yet. We're not done discussing yet, and it will just keep continuing. And eventually, I think those kind of clauses are uncertain. Number one, it's also not good for parties, because I can tell you, as a practitioner, every time we look at these clauses, the clients are always saying, when can I arbitrate? When can I arbitrate? I want to know the timeline. It's important that you put a date there. So parties also focus their minds, right? I mean, you tell them you have 30 days to solve this or you're going to arbitration. And everyone will sit down and really try their best. If you don't, then it's an open-ended process. We can continue for 1 year, 2 years, and things like that. So that's why I've suggested the model approach is to put in a time period. And if you are talking about mediation, set out the rules. If not, if you decide not to go for institution, I think it's okay, as long as you set out the process by which the mediation would take place and the mediator will be appointed.
And this is, of course, from me as a former Indian litigator, like how this operates in my mind. Like I would then put an escalation clause. I'd make sure the other guy does not get an interim relief, either before the arbitrator or before the court. And then suppose the mediation was for 30 days, and then I continue in mutual consent for 60. And then I don't like the outcome. Then I turn back. So can't the time limit also be used in a very tactical manner?
You're right. I think your question is whether you can apply for interim relief, and the other side would just say, well, great, now I have 90 days to drag out this thing and I can go and do some other things in the meantime. I think what will happen in that case is a party, you cannot go to arbitration yet because you're still going through the steps, but you can apply for emergency urgent relief from the courts. The courts have a residual jurisdiction and power to come in to assist with the process. So if you go to court, say, look, we're going through this process of negotiation and mediation. We only get to arbitration in 90 days. But in the meantime, I find that my counterparty is dissipating assets. I have to do something, because otherwise, when I go through this process, all the assets are gone. What's the point of going to arbitration? That's one argument. The other argument you could also make is by that party's conduct in behaving in this manner, the party has waived the preconditions. Because if you think about it, the whole point of negotiation and mediation is we do this in good faith. But if you're going to start dissipating assets, I would take it that you've waived the preconditions. I'll start arbitration straight away. So there could be two options. It really depends on whether you still want to go through the preconditions or not.
Okay. So another question I have from Advocate Rahul Tiwari, I think, that I mean, none of these cases seems to talk about a pro-arbitration policy. Like, so if you look at a escalation clause from that, would you rather enforce it or just override the negotiation part and come directly to the arbitration?
Yes, actually, the cases do. Sorry, I don't have time to actually set it out, but you would notice that there was a shift. We may recall. I said initially the courts were saying, well, we're not enforcing, and then by Emirates, they started enforcing. It was number one, that they will try to uphold parties' contracts. The second policy really was the courts supporting alternative dispute resolution, mediation and arbitration and negotiation. And certainly in Singapore, that comes through very clearly. It's pro-arbitration. The courts will always try to uphold clauses and uphold parties' agreement to arbitrate, even if it has steps before that you need to comply with. And whether it's pro-arbitration or pro-alternative dispute resolution, that's certainly very clear in the reasoning of the Singapore courts.
Okay. So before I move on, Ajay ji, our colleague, Professor Mansi Kumar wants to ask a question, but I am not sure if she has access to the mic. Can you give Mansi access to the mic?
Sure, sure, sir, sure.
So when this happens, I also go to the second question that Rahul is asking. So basically, we break down this clause into step 1 and step 2, right? So you can have an arbitration agreement whereby, like the Thompson case and all, you can also have a non-signatory that also becomes a party, right? So can this extend to step 1 as well? I mean, can you have some mechanism to make even non-signatory, to spread the mediation between people who are not parties to this arbitration?
I think that would have to be, unless that's written somehow clearly in the agreement at the start. I'm not sure that you can know which third party to bring in, right? But even then, even if you write into the clause, assume you write into the clause that parties shall endeavor to, shall negotiate in good faith. And if the dispute concerns a third party, to bring the third party into the discussion, that's okay. You can write it into the clause, but whether the third party would join you depends on the third party. So there's a limit to how much you can do as well. I mean, even if it's not written into the clause, if a matter comes up and it's quite clear that you can't just resolve between the two of you and you need to involve a third party, I think sensible commercial parties would say, let's try to bring the third party in. But again, you face the same problem. Whether the third party wants to negotiate, it's up to the third party. You can't force the third party because the third party was not party to the contract.
Okay. Thanks, Wendy. So Mansi, are you online?
Yes,
Yeah.
Subhajyoti, thank you so much. I was actually busy typing away my question furiously, trying to put this in. Thank you so much, Wendy, for a fantastic presentation. I found it really, really illuminating. I'm very curious, and I just wanted to pick your brain a little bit more on this jurisdiction versus admissibility question, with regard to the preconditions to arbitration, whether you're going to go for negotiation or mediation. And I think you're right that this is clearly a question of contract interpretation. You have to figure out what the parties intended. And I was just curious, I mean, does it seem a bit strained, I suppose, to say that these parties who are arguing that this is really a jurisdictional issue, isn't it a bit strained for them to say that, they have only agreed to arbitration if there is a bona fide attempt to complete these preconditions, given that these preconditions do not result in a binding decision. Negotiation, at the end of the day, it only succeeds if the parties agree. Mediation, at the end of the day, it only agrees if a settlement agreement is reached over there as well. So it seems to me a little odd and, as I said, a bit strained for them to say, no, we only agreed to arbitration if there was a bona fide attempt beforehand, when it's kind of like arbitration was, at the end of the day, the light at the end of the tunnel anyway.
Well, you have articulated it perfectly. Sorry, please go ahead first.
No. I really wanted to hear your take on it, and a little bit more maybe about where you see this debate going. You said you think that maybe the pendulum could swing back, but I was wondering if there are if you have legitimate concerns of this happening anytime soon in any of the jurisdictions that you
Right. I think first of all, in terms of, I think you have articulated the point perfectly. If we think about it, this is like the debate that we saw earlier on as to whether escalation clauses are arbitration agreements. Remember, there were two differing views. one view was that, of course, it's an arbitration agreement because nobody is bound by the initial steps and someone always has the right to refer it to arbitration. And then there was the other view that the Channel Tunnel's old English view, which is that, no, there is no agreement to arbitrate. You only agree to go for negotiation. And it's only if negotiation fails, then the obligation to arbitrate comes in. So if you think about it, it's the same kind of analysis. And for the same issue, the courts have already taken the opposite, shifted to the approach of saying, of course, it's an arbitration agreement. I think the problem that I see, though, is that in Singapore, we don't have our Court of Appeal, and that's the highest court, has held in 2013 that this is an issue of jurisdiction. And so that's how it's been argued in the Singapore courts, at least for a number of years. And this issue hasn't come back up before the courts again. And I'm just not sure how the Singapore courts will actually decide this. I think it's right as a matter of legal analysis, it should be an admissibility issue. They probably will have to say that it wasn't properly argued before then in 2013, and that's why they took that view at that point in time. But I think for those of you who are familiar with the Singapore court cases, our Court of Appeal tends to just take a very odd approach. They like to be different from the other jurisdictions. And that's why I said possibly, they might take a different view. But I'm not sure, I perfectly agree with you, Manasi. I think every case that found it to be a jurisdiction issue in the past never properly analyzed it and never thought about it. Because like I said, right, a jurisdiction issue is you saying that this matter is not to be subject up to any arbitration. It should be heard in a different forum, it should be heard in litigation. But it's actually not what the objection is. The objection is you brought the claim too soon. But it's not that the claim can't be subject to an eventual arbitration. So I am for the admissibility side of things.
Yeah.
But I think the problem is that in the past, people just looked at it as, well, I think it's because of the word used, that these are conditions precedent to arbitration.
Yeah.
They are preconditions to arbitration. So as we all know, as contract litigators, as lawyers, if it's a condition precedent, unless the condition precedent has been satisfied, there is no obligation. So I think that's how it's being analyzed. And I think to this date, people still refer to these as condition precedents. So if that is the legal analysis, right? If these are truly conditions precedents, that's how you construe the party's intention, then until that condition precedent has been satisfied, there is actually no arbitration agreement. There is no obligation to arbitrate, and therefore the tribunal has no jurisdiction.
This is fascinating because I actually, I'm guilty of talking about them as conditions, but it never occurred to me that this kind of a conclusion could be drawn. Actually, with Subrajyoti's indulgence, can I ask a follow-up question?
Yeah, sure. Manasi.
Thank you. So I was just curious, if we then go ahead and say this is an admissibility issue, then it would be for the arbitration, for the tribunal to actually decide whether or not these preliminary steps have actually been satisfied according to the party's intent as evidenced in the contract. Now, if we're not going to allow the parties to challenge the arbitral tribunal's award based on their decision in this regard, would we be trying to set up some kind of maybe an interlocutory appeal, some kind of preliminary appeal if a party feels aggrieved that the decision by the arbitral tribunal is baseless and they have not applied their mind to this? I mean, would that be the outcome then for a party who feels that their agreement, which includes an agreement to negotiate, and maybe it even sets out a timeline, which perhaps the arbitral tribunal, for whatever reason, ignores? Would that then be, should that then be the process that, let's say the Singapore courts or the Indian courts or the UK courts should follow, to say that the party should actually, they have a certain amount of time to appeal the matter immediately, and thereafter they have waived their argument? I think that
in model law countries, and also in Singapore, I'm not sure about India. In Singapore, appeals are allowed from tribunals' decisions only if it concerns an issue of jurisdiction. And that's why there is this debate about whether it's a jurisdiction or admissibility issue. And if it's an admissibility issue, then it goes to the merits. And the courts, because of their pro-arbitration policy, have held that they're not going to decide whether the arbitrators are right or wrong, because that's getting into the merits. That's something that you agreed to let the arbitrators decide. So I think that is the policy. I mean, what you have articulated is probably what would drive a policy decision by the courts to find it as a jurisdiction issue rather than an admissibility issue. And that's how, if someone has that mindset and has that thinking, it's actually quite unfair because I agreed to this process and the tribunal gets it all wrong, and then I'm forced to arbitrate, but that's not what I agreed to. Then if a court analyzes it that way, then they might frame it as a jurisdiction issue, and that's how they will fit it within the model law framework. As a jurisdiction issue that you can appeal against after 30 days. Or if you choose not to appeal it, then you could challenge the award subsequently on the issue of jurisdiction.
Okay, so depending on how tough the facts are, or how perhaps unjust the facts appear, it might be a case of the tail wagging the dog. The outcome might dictate the approach that a court takes.
That's correct. That's correct.
Thank you very much. Very fascinating.
So Wendy, just one thing to add, because it seems to me that the basic concern here is that the matter might meander into court and finally may defeat the autonomy of the parties. But now that you have the Singapore Convention, the mediation convention, so is that concern really there? Like you can enforce the mediation agreement in its own right. So why come to this circuitous route?
Right. If I understand your question correctly, why agree to mediate before arbitration since we have the Singapore Mediation Convention, which is already enforces mediation agreements?
Yes, but the basic issue is that the whole concern was that if we don't enforce the escalation clause, that the parties are not going to go for arbitration and finally avoid the arbitration, go direct to court. So now that the first step, the step one, as we can call it, is also enforceable.
Yep.
So is that concern, I mean, is this whole thing of jurisdiction, severability, admissibility not becoming more theoretic now? We have that convention.
I don't believe, yes. I don't believe so, because I think mediation agreements are just agreements to mediate. These are clauses that provide for the next step if parties can't agree during the mediation. And we all know many times people don't agree on the outcome, even though they refer the matter to mediation. So it's still a relevant issue because unless parties agree on even if parties agree on standalone agreements, a mediation agreement and an arbitration agreement, I think most likely the arbitration will still be made conditional upon or subject to the mediation agreement, in which case you will still have the same issue always. If you can't resolve by mediation, or someone doesn't want to go through mediation and starts arbitration, then does the tribunal have jurisdiction, or is it just an admissibility issue that the tribunal can say, well, I'm just going to stay the arbitration in the meantime, and you go ahead and resolve this matter through mediation first, and if not, come back to me.
Okay. So students, if you have any more questions, you can please type it out. So I don't see any more questions. Let me see if I have any in WhatsApp. So Wendy, thank you so much for your brilliant presentation. I mean, you have taken a great deal of time. You have made so many slides. Thank you so much. It was very illuminating for our students. I hope that we can have you on campus if we come to India and if our campus opens whenever it does in future. Right. Thank you so much for your time.
Thank you. Thank you everyone for having me here. I must say, I will let you guys know that I'm spending first day in quarantine today in Hong Kong. I was a bit worried I was not going to make it because the process at the airport took a lot longer. But I'm glad I made it here. I'm glad I'm spending my first day in quarantine with you guys. And thank you for helping me spend my first day of quarantine very meaningfully.
Thank you so much, Wendy. And thanks our IT team and the students for their participation as well. Thank you guys.
Yes, sir.
See you. Bye.
Thank you. Bye-bye.